Honored to have Jeremy Saland with us right now, the former Manhattan prosecutor, criminal defense attorney. Jeremy, great to have you. How do you think this is looking for the prosecution right now?
In terms of the entirety of the case, or what we're just talking about?
The entirety.
You know, the evidence is going in fairly solidly. I think they've done a good job. I think it's also a difficult lift, meaning that there's plenty of people who will say, why are we doing this? But whether or not you're saying, why are we doing this? It is a case. Look at the four corners of that courtroom. What is the evidence? Have they established proof beyond a reasonable doubt? And what, if anything, is the defense going to do to challenge? Because as of now, their goal, I believe, is to make it look like it's the Stormy Daniels blackmailing story and the Michael Cohen lying, non-credible story. They want to move it away from falsifying business records. It's not an easy thing to do, but that's their objective.
So in the case of Michael Cohen, they're obviously trying to dig, and that is the defense, and test his credibility, that he lies, and that he might have even, in fact, perjured himself on the witness stand. I don't know how true any of that is, but he looks like damaged goods. And to the jurors, I think the defense is trying to say, you're going to believe this guy?
Well, a couple of things. First of all, I don't think he perjured himself. They're not mutually exclusive to say, okay, I spoke to you about one thing, here are the texts to corroborate that, but I spoke to you about something else as well. Those texts are not sort of the gold mine for the defense.
So the defense, reaching for that might be an overreach.
It's a bit of an overreach, but they're doing their job because anything you need to do, you should do, which means you want to make Michael Cohen look like a dishonest person. You want to make Michael Cohen look like someone who's selling out for his own gain and out of vengeance. But keep in mind, and I say this repeatedly, both as a prosecutor and as a criminal defense attorney, if your main goal is to get the big bad guy, and I'll use the term of the bad guy in the enterprise or the kingpin, who are you going to get to do that? Not a choir boy. You're going to get the person who has his hands dirty, who's involved in the scheming. That's how you're going to get the main bad guy. Now, I'm not saying the former president is a drug dealer or a kingpin, but that's the same concept. You got to get the bad guy to get the bigger bad guy.
All right. Now, I know what they're trying to say here, obviously, on the misdemeanor side, if that's all limited to, and that's what the defense said, this is no more than a misdemeanor irregularity. You have to bring it up to the felony charge, start proving intent, that if you're writing checks or secretly writing checks for one account, another account, with the intent to cover something up, I guess in this case for the election, violating state law, violating federal law. That's a tough leap, isn't it?
It's a more difficult lift than, say, for example, a grand larceny, because we can look at a record and show there's been an embezzlement and you have the paper trail and you're good to go. It is a much more difficult thing, and it's also because it's unique. How often do you hear that happen? Now, what's going to ultimately occur is the defense is going to ask for a trial order of dismissal, say, listen, when the prosecution is done, they didn't get all the elements established.
Happen, right?
But it's a very low bar for the prosecution at that stage in the process.
But is any of this appealable? In other words, if it goes through the jury, takes this up, convicts the former president on one or several of these charges, you hear from a lot of lawyers that there are some appealable grounds here. So what are we looking at?
Even if there is an appeal, which very well could be appellate grounds, that takes time. So does that mean that ultimately he wouldn't be convicted? Well, that's yet to be seen. But if he is convicted on a misdemeanor or a felony, he has that right to appeal. And I would submit and say to you, if I am the prosecution, I would ask the judge not even to allow the misdemeanor to be convicted. It's all or nothing. I'd want just the felony. I wouldn't want them to hang their hats on a misdemeanor, because that would be a loss, I think, for the prosecution. Same way a mistrial would be if you hang one jury. But as of now, the evidence has been going in very well. But listen, Michael Cohen, if you can make it about him as an incredible or dishonest person with an agenda, that can certainly poke holes in the case for the prosecution.
And we have no idea what the jury thinks, right? They're the ones who decide this.
A sleeping jury is a acquitting jury. A sleeping jury is a convicting jury. So you simply don't know.
Oh, that's interesting. All right, Jeremy, you're good at this, my friend. I appreciate it. Jeremy Saland is the former Manhattan